Hi friends, good morning. This is Priyanka from CS Priyanka's Professional Classes. Welcome to my channel. Hope you are well. So today I'm making this video on the topic director, and I named it as part 1 because director is a big topic. So I need one more part to complete this topic. And in part 1 I included all the types of directors and their details, but in part 2 I will include reappointment, vacation, dean, their qualification, disqualification, all these things, and rotation of directors. All these things I'm going to include in part 2. Hope you will be benefited from my video. So let's start. So the topic directors. Before starting or before going into depth, I would like to say that directors are of two types: executives and non-executive. Executive directors means whole-time director, non-executive directors means part-time director. Whole-time directors, example like manager, managing director, these people are known as whole-time director who works whole time in a company from 10 to 5 like other employees. These are employees of the company. But non-executive directors are actually not full-time employee of a company. They are not eligible to take the remuneration. They only attend the board meeting and they take the fees like sitting fee for their visit. But normally whole-time directors are eligible to get the remuneration from the company. So this is all about directors. So let's start. There are many types of directors. So today in part 1 I'm going to discuss about all the types of directors as per Companies Act 2013. Director, section 152. Director is coming under section 152 of Companies Act 2013. This director means normal director or original director, you can say. Every director of a company usually appointed in general meeting. Okay, so general meeting, there are two types of meeting in a company: board meeting and general meeting. If you are having any confusion relating to the general meeting, then you can do the video which is there in my channel already on the topic meeting of the Companies Act. So do that class, then you will be it will be very much clear for you that what is general meeting actually. General meeting is nothing but a shareholders meeting. And every directors are usually appointed by the company in shareholders meeting. Without the consent of shareholders, it's not possible to appoint directors. Second point, the main requirement for director is to obtain dean. Dean, the full form of dean is director's identification number. That means if the director is got appointed in shareholders meeting, from the next day onwards he cannot be the director of a company legally, if you see. So being a director, main requirement is like that the director needs to obtain identification number, director's identification number. For that he needs to apply to the ROC, and ROC will issue DIN number to the director, and on receipt of such DIN number, a director will become a director of such company. If he is a whole-time director, then okay, he can work in one company only. He cannot work more than one company as a whole time. But if he is a part-time, then he can work or he can act as a director, means of maximum 20 companies. He can be a part-time director of maximum 20 companies, and he is going to receive, or ROC is going to issue only one DIN number in favor of 20 companies if he is a part-time director of 20 companies. So director means the main requirement for a director that to obtain DIN number. Third point, a person to be appointed as a director shall furnish his dean and declaration that he is not disqualified to become a director under his act. So this is a very important point, that whenever he is getting appointed or he is appointed as a director, first and foremost thing, he need to submit the declaration that he is not disqualified under this act. What do you mean by disqualification under this act? That means he is not an insolvent person. He is not an unsound mind person. He is an active mind. Unsound mind means the person who is having who is not having any decision making power. Those persons are known as unsound mind. So he is an active person. He is not an insolvent person. He has not been convicted by court of law or anything like that. So this type of disqualification is not there. So whenever and that proof he needs to submit in the company, okay, before his appointment. Last point, he needs to give his consent to hold his office as director, and same is to be filed with registrar within 30 days in form number DIR2. Such consent needs to be filed with registrar in DIR 12 along with fee prescribed. So what happened? Company cannot force any person to act as a director. So that's why consent letter needs to be obtained from that individual who is going to be appointed as a director. So what the person or individual who is going to be appointed as a director, that person should give his consent in writing that he is willingly wants to work with such company as a director. Such consent he will give or needs to be obtained by the company in form number DIR2, and such consent needs to be, and now company got the consent, and now for every step company needs to intimate ROC, registrar of companies, the authority of the company. So how he will intimate the ROC? Company is going to intimate about this consent to ROC by filing form DIR 12 along with fee prescribed in the act. So this is all about normal director and his appointment. Next, first director, which is coming under section 152 subsection 1 of Companies Act 2013. So what do you mean by first director? First director are the directors who are named in the article. So first director in the sense, like whenever you are incorporating a company or you are forming a company, who were the first director in such company? So how will come to know? Like we all know ki there are two incorporation documents are there. Documents. One is MOA, Memorandum of Association. Second one is Article of Association. So this article means AOA, Article of Association. What you have to do if you are asked what are the name of the first directors or what is the name of the first director, then you have to check in Article of Association of such company whose name is written, who name is written there, that person is known as first director. Now think, nothing is mentioned in the article. Article is fully silent relating to the first director. Then check Memorandum of Association, last page, or the subscriber to the memorandum. So whoever will be the subscriber to the memorandum, those person will be the first director or shall be the deemed to be the first director of the company, and until next the directors are duly appointed by the company. Okay. And last point, in case of OPC, there only one person is there because OPC means one person company. The one person, same person is a member, same person is director. So there is no other requirement needed. So whoever is there, that natural person is that the one person who is doing the one who is running the OPC, same person is the first director of the company. So first director means the person who is named in the article. If article is silent, then you have to check who is the subscriber to the memorandum. That person will be shall be deemed to be the first director until the directors appointed by the company. And in case of OPC, there is the same person who is carrying on or running the business. Same person is a member, same person is the director, and he is only the first director. Next is additional director, whose section is 161 subsection 1 of Companies Act. Now, additional director along with the original director, this is an additional one. That means one extra. So here shareholders permission is not needed. So board resolution need to be passed in board meeting for the appointment of additional director. So here for appointment of additional directors, board members only can take the decision. Okay, so share if your article is authorized. That means if in articles it is written that any time or as per requirement the company can appoint additional director, then board members are having power to appoint such additional director by passing board resolution in the board meeting. Now think article is not authorized. Article is not authorized means nothing is mentioned in the article. In such cases, they can pass special resolution to amend the article. Now, if you are it's not clear about, if you are not very much sure about special resolution and board resolution, then you can do the classes from my channel. It is already uploaded along with the meeting. So do it, what is special resolution and what is ordinary resolution, then it will be clear to you that if article of association is silent relating to this matter, that is appointment of additional director, then you can pass special resolution in general meeting and can amend the article. You can include the clause in the article, then you can appoint additional director. And finally, whenever the additional director will be appointed, additional means what? One extra. Whoever are there is okay, one extra director is coming. So here what happened, all the other existing board of directors will appoint such additional director, and such additional director will hold the office till next or coming AGM. AGM means annual general meeting. Till next AGM he will hold office. In the AGM only again he will be reviewed by the shareholders. Okay, he can be changed or he can be reappointed, but as per law he will hold office till next or coming AGM. For example, think AGM date fixed on 30th September some year. Okay, that person appointed on 28th September 2019. Now AGM date fixed on 30th September 2019 and the person appointed on 28th September 2019. Now as per law, that additional director who will hold office only for 2 days, because after 2 days AGM is going to be conducted, and in AGM again he will be reviewed by the shareholders and he will be reappointed till next AGM. Again in next year 2020 AGM he will be reviewed or else he will be reappointed. So additional director will hold office till next or coming AGM. This is a very important point under additional director. Next is alternate director. Its section is 161 subsection 2. Now alternate director in the same, what do you mean by alternate director? Alternate, that means in place of some director some alternative person is coming. Okay, so you are alternating some existing person or existing director with a new one. Alternate. So now alternate directors, for appointment of alternate directors also same like additional director, like board members are having power to appoint alternate directors. So if board members are only having power to appoint, so no need to take this matter into the general meeting and no need to pass special resolution, no need to take permission from the shareholders. So board members or board individuals or member of the board will appoint alternate director by passing board resolution in board meeting. Now same thing like additional director, there should be the clause in article of association. That means the company should have access to appoint alternate director. If article is not authorized, that means if article of association is silent relating to this matter, that is appointment of alternate director, then board members can pass special resolution to amend such article. Okay, amend means they will include or they will insert the clause there, and they now they will amend the article that the company can appoint alternate director. Whenever they will amend the article, that means they're getting the access to appoint alternate director. Board members can appoint alternate directors by passing board resolution in the board meeting. Now, an alternate director will hold office for an original director during his absence for a period not less than 3 months. Whenever original director will be absent, okay, and the period should not be less than 3 months, then only company can appoint any alternate director in his place. Okay, if the original director is absent for 2 months or less, then not needed. Appointment of alternate directors is not mandatory or not needed itself as per act. But when the original director is absent from the office of his office, uh, that is 3 months or more, for a period 3 months or more, that then company can appoint alternate director in the place of original director, and such alternate director will hold office until the original director return to the state. So it's a contract basis. He will hold for that period only. You are okay. Whenever the original director will come back or return to the state, he has to leave that position. So alternate director will hold office until the original director return to the state. Now, there are some other directors other than first director, alternate, and additional, like a woman director, requirement of woman director. This woman director concept is also there in Companies Act 2009. It is coming under section 149, subsection 1. Woman director is required to be appointed in every listed company. Now, what do you mean by listed company? Also, video is there in my channel. Please do the class. It will be clear to you. That means the company whose shares are listed in any recognized stock exchange. And for every listed company, out of all directors, one should be a woman. And secondly, for every other public company. This public company in the sense, normally public public listed company, public unlisted company. First one is for listed, and this is public, the normal public company Ltd. Then you have to check the threshold, that is paid up share capital if it reach 100 crore or more, or turnover if it exceeds 300 crore. Then it is mandatorily such a public company should appoint one woman director. So requirement of woman director is means as per Companies Act only for this two purpose. For listed company and for public company, you have to check the threshold. Paid up capital exceeds 100 crore, turnover 300 crore or more. Next is independent director, which is one of the most important topic in full professional, like full CS. It may be CS inter, CS professional, CMA, everywhere, and in also as well as in corporate life also. Independent director concept is very much important topic, and the section is 149 subsection 6. Now, first, I would like to discuss independent director. From the name itself, it will be clear that the director who takes the decision independently. Normally, the board of directors are usually are not capable of taking the decision independently because there are many directors. 3, 4, 5, 6 directors are there. So altogether they take the decision and pass the resolution. But independent directors concept is that it will be clear from the name itself they are independent enough. That means the directors who take the decision independently, and they plays a very main role in a company. If one independent director is there in a company, they plays a crucial role in such company. Now, point number one, like when first of all, I would like to discuss that when independent directors appointment is mandatory, or the requirement for the requirement of independent director is compulsory. In case of public companies, you have to check the threshold, like paid up share capital is 10 crore or more, and if turnover exceeds 100 crore, immediately such company needs to appoint one independent director. Secondly, here I have included in the third point that if other than these also, if such public companies total outstanding or debenture deposits if exceeds 50 crore, so much debts outstanding, if it exceeds 50 crore, then also it is mandatory to appoint one independent director in such company. So relating to the appointment, what is mandatory, when it is mandatory to appoint independent director? First is if in a public company paid up share capital exceeds 10 crore, 10 crore or more, turnover 100 crore or more, and if the total debt, outstanding loans, debenture deposits exceed 50 crore. It is mandatory to appoint an independent director in such company. Okay. Next is independent director. I already said ki independent director has a crucial role in corporate governance. Corporate governance means it's a vast thing like a how to govern a corporate. It is not a specific topic. Corporate governance means it deals with everything, all committees, all boards, all decisions. Corporate governance, how we will govern a full corporate. Okay, so independent director, if in your company one independent director is there, such person has a crucial role in corporate governance. So it is already said presence of at least one independent director is required to call a board meeting at a shorter notice of less than 7 days to an urgent transact an urgent business. So what happened if there is one independent director in your company, then what happened, that independent director is having power to call board meeting at a shorter notice. Normal board of directors you usually call board meeting at a 7 days notice, but this independent directors, if one independent director is there, then he is having that power to call a meeting at a shorter notice, that is less than 7 days. They can shorter notice of less than 7 days to transact any business. That power independent directors have. Continuation, point number 5. Independent directors plays an important role in determining the level of remuneration among executive directors, key managerial person and senior management. In a company, if one independent director is there, then he will fix the uh, remuneration of all other key managerial personnel like executive directors, that means whole-time directors. Under KMP who are coming, CA, CS, CEO, CFO, all these people are coming, managers. All these people's remuneration will be decided or fixed by such independent director. Now, even if in a company any audit committee is there, then independent director has a strong influence on audit committee, as a majority of audit committee consists an independent director. So as per Companies Act, audit committee, if your company is having audit committee, then audit committee should consist maximum independent directors, majority of independent directors. And that's why it's a normal independent directors is having a strong influence on audit committee. Next is the company and independent director. Whenever in a company, the independent directors usually work as per Schedule 4 of Companies Act, because their do's and don'ts are mentioned in Schedule 4 of Companies Act 2013. Next, 8. He shall not be entitled to any remuneration other than sitting fee. But most important thing is, independent director is not an executive director. That means he is a part-time director, non-executive director. So he is not entitled to any remuneration. He never takes remuneration from such company. He takes sitting fee. Okay, whatever board meeting he attends for his services, whatever he is giving to such company, accordingly he takes the sitting fee. Along with that, if he do any expenditure relating to that business, okay, relating to that business or relating to such work or his service, okay, to such company, then he is having that right to take the reimbursement of such expenses from such company. And also, if the company is on profit, then if on the basis of his performance he is entitled to commission also from such company. Okay, subject to approval by members. Members means shareholders. So if shareholders give permission on means on his performance, also on the basis of the profit, he is entitled to get the commission from such company. So he is not entitled to take remuneration from such company. What he will do, whatever services he will give, accordingly he will take sitting fee. He can reimburse the expenditures, whatever he will do. Along with that, if on the basis of his performance profit, subject to approval of shareholders, he can get the commission from such company. Next is, once independent director is appointed, he will hold office up to 5 consecutive years on a board of company. Okay, that means continuously he is eligible to work for 5 continuous years. After, on the 6th AGM, he is going to be reappointed, or else he can be changed. Okay, company can change him, or company can appoint a fresh independent director on 6th AGM, or else he can be reappointed on the 6th AGM. But once he got appointed, he will continue, he can continue for a consecutive 5 years on the board. And he is not liable to retire by rotation. Obviously he is not a full-time director or whole-time director, so here also retire concept is not coming. So retire by rotation concept is not coming and not applicable for an independent director. Next is nominee director. This is a very rare thing. Nominee director are coming under section 149 subsection 7 of Companies Act. What do you mean by nominee director? Nominee director means a director nominated by a financial institution or appointed by any government or any other person to represent its interest. Normally, nominee directors are not required in case of any companies, okay, as per Companies Act, but nominee directors are appointed usually by the financial institutions. Financial institutions means it may be a bank, okay, any type of financial activities they do, or else any other companies who are non-banking but do the financial activities. So such type of company needs nominee director. Okay, but in case of nominee director, usually financial institution nominate that person, but he is appointed by the central government, and he usually appointed for in a financial institution only to protect the interest of the means to protect the interest of such financial institutions, because nominee directors usually protect the interest of financial institution or else bank. If it is bank, is also a financial institution, it's a banking financial institution, but other than bank also there are many non-banking financial institutions, that means which are not actually a bank, are not coming under the banking regulation, but those are companies whose main object is to relating to the financial activities. Though there also nominee directors are required. So these people are appointed to protect the interest of such financial institutions or banks. Nominee directors are usually non-executive directors. They are not executives. So obviously executive directors get remuneration. Non-executive directors get sitting fee. So nominee directors are non-executive directors, and they are not going to be treated as an independent director, obviously. And nominee directors, though he is a non-executive director, he will get sitting fee. Okay, they are eligible to receive sitting fee, and they are not eligible to receive any remuneration from such company. So now last one is resident director, which is section 149 subsection 3 of Companies Act. But the concept of resident director is now not there in our book or in our corporates. So but the concept is there in the act. Okay, for examination purpose it may be required, like companies incorporated between 1414 to 3914, whatever companies were incorporated between this during this period should have a resident director. And resident means ROI, resident of India. That means that person should be in India at least 182 days, okay, or more. So then that such person will be treated as resident. And during that period, the concept came that means whatever companies incorporated between 1/4, okay, uh, till means 1st April till 39 2014, whatever companies were there, so such company should have at least one ROI, resident director. So and it's either they will appoint such resident director at the time of incorporation or else within 6 months from such incorporation. But at present, as per new provision, all directors can be foreigner not residing in India. But it was not actually logical now, because nowadays board meetings, all meetings usually this happens through video conferencing. All this technology came, and it's not possible for a director always to sit in India like that during. So this concept is not there now. At present, as per new provision, all directors can be foreigner, and it may not be not required to be resident always. So this is the last one, resident.